Today we will be looking at the area of private international contract law, and in particular at the United Nations Convention on Contracts for the International Sale of Goods, generally referred to as the CISG or the Vienna Convention. So what is the Vienna Convention? The Vienna Convention is an agreement established under the auspices of the United Nations and was introduced by the UN Commission on International Trade to allow businesses overcome choice of law issues as regards the law applicable to their contracts. To do this, the CISG created a harmonized system of contract law on which businesses can rely when entering into international contracts. Fundamentally, the Convention represents a compromise between civil law and common law contract rules, but it is probably dominated more by civil law principles. Most of the world's modern economies have signed the Convention, with the notable exception of the United Kingdom, India and Japan. However, developments in the UK suggest it may well be adopted into UK law in the foreseeable future. So what is the organisation of the Vienna Convention? Well, the Vienna Convention is broken up into four main sections. Part 1 deals with the scope of application of the Convention and sets out general provisions. Part 2 establishes the principles governing the formation of a contract, for example, when an offer can be revoked, the situation concerning conflicting terms and conditions, etc. Part 3 puts in place the sale of goods obligations of both buyers and sellers, for example, when risk passes to the buyer and the consequences of fundamental and non-fundamental breach of contract. Breach is referred to as contract avoidance in the lexicon of the CISG. Part 4 sets out the final provisions concerning the coming into force of the Convention and any permissible derogations. To what agreements does the CISG apply? The CISG applies to international sales agreements for the sale of goods. International agreements are primarily defined as sales between a seller and a buyer residing in different states. Normally, at least one of the parties must be located in a CISG contracting state, although this is not always the case. Importantly, in order for the Convention to apply, there is no need for either the goods to be delivered across a national frontier or for the contractual offer and acceptance entered into by the parties to be made in different states. The Convention only applies to commercial contracts and not to contracts entered into with consumers. Moreover, even if the parties are from CISG signatory states, they can choose to exclude its application from their contract, which indeed parties often do. This normally occurs where the provisions of the CISG contradict some of the terms of one of the parties' national contract law provisions, as is the case with common law countries such as the United States. What are the differences between the Vienna Convention and US contract law? US law on the sale of goods contracts is set out in what is referred to as the Uniform Commercial Code, or the UCC. There are some differences between the UCC and the CISG, which explains why US companies sometimes exclude CISG provisions when entering into international contracts for the sale of goods. Some of the main differences between the CISG and the UCC are as follows. The first is the scope of the UCC. The UCC applies to both consumer and commercial transactions, whilst, as we have seen, the CISG only applies to commercial transactions. Also, there is a difference as to whether contracts have to be in writing. Under the UCC, contracts for amounts of over $5,000 must be in writing. However, there is no such requirement under the CISG. There are also other differences, for example, concerning counteroffers or modifications. Any modification to an offer automatically becomes a counteroffer under the UCC and brings the original offer to an end. Under the CISG, in order to amount to a counteroffer, thereby bringing the original offer to an end, the modification must be significant. Also, there is difference concerning the breach of a contract. Under the UCC, breach of a condition of a contract allows automatic termination of the contract. Under the CISG, behaviour can be corrected where the breach does not cause excessive inconvenience to the victim of the breach. And finally, there is difference concerning good faith. The CISG does not make any specific provision for the parties to perform their contracts in good faith, whilst this is certainly a requirement under the common law and the UCC. Now we're going to look at the interpretation given the Vienna Convention. Since the Vienna Convention establishes a system of uniform law designed to be applied in the same way in all CISG contracting states, it is essential that the national courts interpret its provisions in the same way. National courts are consequently required to recognise the international character of the CISG and to be open to taking into account judgments from other jurisdictions. To this end, the relevant United Nations authority has established a resource referred to as Case Law on UNCITRAL Texts, or CLOUT, making available decisions adopted throughout the world concerning the application of the CISG. We hope you enjoyed this introduction to the area of private international law.